Now, a government can enter into contracts. Why do I say this is because currently we are now looking at the topic of the liability of the government. So, first we need to understand, can the government enter into a contract, and for that purpose we look at Article 29 of the Constitution of India. What does Article 29 of the Constitution of India say? The provision goes on to say that any contract with the Government of India must be made in the name of the President or the Governor, as the case may be. So, this does allow for the government to enter into contracts with persons, but it must be done in the name of the President and the Governor, and the contract must be executed on behalf of the President or Governor of the state, as the case may be, but the contract shall be executed with the government only if it is it is considered to be valid only if it is in writing. A person duly authorized by the President or Governor of the state can execute the contract. So, we can see that it must be in the name of the President or the Governor, it must be in writing, and a person authorized by the President or Governor can execute the contract. But they go on to say that the President or the Governor shall not be held personally liable with respect to such contract. Now, all of this is okay, because on the face of it, it's saying that Article 229 allows for entering of contracts into the by the government. Now, one small factor that everyone is required to know is, in contract law, we have the principle of privity of contract, and in privity of contract, only the parties to the contract can actually have rights against each other. And how do we know who the parties to the contract are? The parties to the contract will be specified within the contract itself, and Article 299 says that the President shall be one party, and let us say over here Anish is the second party. He is the person with whom the government is entering into a contract with. But then they are also clear on one thing, that the President shall not execute the contract, some other person shall execute the contract. Now, let us say that there is a contract between two persons. If there is a breach of contract, one party can claim damages against the other party, in the sense that he can claim some kind of compensation from the person who committed the breach of contract. Now, let us say over here that the President committed the breach of contract, or since the President is actually representing the country, the government has breached the contract. Now, if the government has breached the contract, then technically Anish can go before the court of law and file a suit against the President of India. But this is where the loophole arises. Article 299 clause 2 says, the President or the Governor shall not be held personally liable with respect to the contract. So, that means even if Anish takes the President of India to court, which by itself will not be allowed to happen, even if he takes the government to the court, then the court cannot enforce this contract and cannot ask the President or Governor to be personally liable. So, this creates a loophole wherein Anish is left defenseless, or he is incapable of getting an actual remedy under the court, from the court of law. So, what the court has done over time is, they have interpreted section 65 of the Indian Contract Act, wherein they are saying that if an agreement is discovered to be void, or when a contract becomes void, any person who has received any kind of advantage under that agreement is bound to restore it or make compensation to the person who received it. So, in this case, if the government has benefited of this contract with Anish, then the government is required to restore it or make compensation to the person who has from the person who's received it. Therefore, an agreement with the government is void if Article 299 is not complied with. The party receiving the advantage under the agreement is bound to restore it or make compensation for the to the person who has received it. So, what exactly is the effect of a valid contract with the government? We are saying that as soon as the government enters into a contract, Article 299 comes into play. Now, an interesting question was asked, whether a writ of mandamus can be issued against the government to enforce contractual obligations. What is a writ of mandamus? A writ of mandamus is a command. To whom? To any public authority to carry out its public duty. Correct? So, when the government enters into a contract with any person, then we can say that a duty arises to enforce that contract. So, since any contract that the government enters into is of a public nature, the Gujarat State Financial Corporation versus Lotus Hotels, the court went ahead and said that yes, the writ of mandamus can be issued against the government or its instrumentality for the enforcement of the contract. The next question that was asked was whether a contract can be struck down as void as violative of Article 14. In Srilekha Vidyarthi versus State of UP, it was held that whenever the state enters into a contract, it is said to be a public action, and the contract must always be for the public good, and hence the contract is subjected to judicial review. If the contract is found violative of Article 14, then it can be struck down as void. So, we can see that a contract by a government is allowed, but it is also subject to the test of Article 14, and a writ of mandamus can also be issued against such a contract. The last topic that we are going to be looking at over here is the liability of a public corporation. Now, what exactly is a public corporation? We can refer to any public corporation as any organization that was incorporated under any act of parliament or legislative assembly, in the sense that they are saying that the management, the powers, functions, rules, regulation, employees, etc. are all specified within the concerned act. Okay. So, what are the main features of the statutory corporation? It has to be incorporated under any parliament, any law of parliament. It is an autonomous body. It is to be free from government control, and its internal management will be accountable to the parliament, but at the end of the day, it will still be an independent body. It has a separate legal existence because at the end of the day, it is still a company registered under the Companies Act. It is managed by a board of directors composed of individuals who are trained and experienced in business management, and some members of the board will be nominated by the government. It is supposed to be self-sufficient in financial matters, however, it can take a loan or seek assistance from the government. But the employees of these enterprises are recruited as per their own requirement, and they are not to be considered as government servants. So, as we can see over here, the benefits of a public corporation is that it's free from governmental regulations. It has a lot of flexibility in operating in financial decisions. A public corporation comes under Article 12, and fundamental rights can be enforced against it. A writ can be issued against corporations too. But the problems is that we are unable to reconcile with the public accountability of these corporations. And because employees are not considered as government servants, they are not protected to they are not entitled to protections granted under this law, and such as no civil servant shall be dismissed without an inquiry and an opportunity of being heard. Now, this applies to government servants, but since the employees of public corporations are not government servants, they do not get the benefit of this law. Okay friends, so we have come to the end of our administrative law chapter. Please note that the topic, that is liability of state in torts, is the topic that can be seen in the law of torts chapter and will be accordingly done over there.